for. If you look through, they don't expressly say it, but my belief is that they're withholding these documents because they say they're in the AG's possession and not the defendant's possession. So Judge, the relevant inquiry is what is possession, custody, or control under the law? And under the GTE case, which is a Texas Supreme Court case, it includes constructive possession and the right to obtain possession from a third party, such as an agent or a representative. In this case, Your Honor, we've produced evidence that shows that the AG, the German entity, is the manager of defendants. Sorry about that, Your Honor. We've produced evidence that shows that the AG is a manager of the defendant LLCs. That is Exhibits A, D, and E to the reply. In each of those documents, the AG is identified as the member. And if I can show my screen, Your Honor, the corporate documents.
Go ahead.
The corporate documents that have been produced, Your Honor, this is Exhibit A1 to the reply. And it says, Global Texas and Global Oklahoma, which are the defendants here. The sole member is Global Oil and Gas AG, which is the AG that I've been referring to. And as we go down to the next page, it describes what the AG has the power to do. And it says, the undersigned is the sole member, therefore has the authority to represent Global AG as the Vorstand. And then, Your Honor, these amended company agreements, which they've put forth. This here is Exhibit D6, and it shows that the business.
You're not sharing screen. I don't know.
Oh, maybe it's my fault. I don't see that I have the option to, Your Honor.
You should be able to. Unless there's something wrong with Zoom, I've enabled it.
There we go. How about now?
Yep.
Okay, so you'll see here, Your Honor, Exhibit D6, and it shows the powers of the AG in connection with the defendant. And this one, I believe, Exhibit D, I believe is for the Texas entity, but I could be mistaken, Your Honor, but Exhibit D and Exhibit E are identical. One is for the Oklahoma entity, one is for the Texas entity. And it says here, the business and affairs of the company shall be managed by the member as its sole member. The member shall have full, complete, and exclusive authority, power, and discretion to manage and control the business, affairs, and properties of the company. The company here is one of the defendants, Your Honor. To make all decisions regarding these matters and to perform any and all other acts or activities customary or incident to the management of the company's business, property, and affairs. So as you can see, and I can stop sharing my screen, Your Honor. As you can see, the AG is the manager of each of the defendants' companies. Under Texas law, a manager is an agent of the LLC, right? Under Texas Business Organizations Code 101.254. So therefore, I think we've shown that they have the right to control those documents. They've produced, notably in this case, Your Honor, a number of documents from the AG. They've produced nearly 10,000 documents, separate documents that predate January 1st of 2017, which is the relevant date for our discovery responses. They've produced a bunch of documents that are from Global. For example, they've produced Global AG's financial statements. They've produced the IPO, the initial public offering for Global AG. This is important, Your Honor, because 2007 predates both of the defendants' recognition as companies. The Global Oklahoma Fields entity was created in November 10th of 2008, and the Global Texas entity was created August 10th of 2018. So I think from that, it's pretty clear that they've got possession of the documents. They're choosing to produce what they want to and not to produce what they don't want to. Further, Your Honor, if I could share my screen one more time, in connection with our third motion.
I thought you said you only had two.
Oh, I'm sorry. In connection with our second motion that we're addressing today, which is on the defendant's third set of discovery responses.
Okay.
Let's see. I don't know. I don't see that I'm sharing. Share. Can you see this, Your Honor?
Hi. Ich nehme gerade an der amerikanischen Gerichtshof.
Is this Oliver Kotschied? Is he on this case?
Yes, Your Honor.
Okay, there was some noise coming out of his. No worries. I just want to make sure he's supposed to be here. So go ahead.
Sure. So if you see, Your Honor, this is page 4 to 5 of the defendant's response to our motion about the third set of requests for production. They say here defendants continue to work with their parent company to attempt to acquire the remainder of the Mater documents and will produce the same as appropriate and as soon as practicable. So, Your Honor, I think it's pretty clear that they've got the right to obtain possession. They're currently doing it in connection with some of our requests. So for that, I would say, you know, we've shown that the AG is the manager of the defendants. We've shown that they have the exclusive authority to deal with defendants' business matters. And that by their own admission, they're able to obtain these documents. So, Your Honor, I would ask the court in connection with this AG issue to order the defendants to search for all the responsive AG documents and produce them.
Okay.
And then moving along, the next issue that we've got that pertains to both of these motions is these hard copy documents. And I'll tell Your Honor, the defendants have, in response to a number of our requests, said that they'll make hard copy documents available for our inspection and copying. The problem that I have with that, Your Honor, is that they haven't said what documents they have and which requests they're responsive to. We've asked them a number of times to clarify their position. They just say, you know, hey, we've got a bunch of hard copy documents. You can come look at them if you want to. I know that the rule is that they can produce documents for inspection and copying. That's fine. But I think a basic tenet of the rules is that the documents that are produced must be requested or responsive. That's Rule 196. So in connection with that, we would ask them to tell us.
Ms. Bowen, explain to me exactly what you're saying. So they're saying they have a bunch of hard copy documents. You can come inspect and copy, but they're not saying which documents are responsive to which request. Is that what you're saying?
No, they're not saying for any request that they've got documents that are responsive to them, if that makes sense, right? It's not, you know,
No.
if you take a look at the third set, for example, in the general reservations, they say, we've got, you know, hard copy documents that will make available for inspection and copying, but they don't say in the request, they don't say that those documents are responsive to any specific request. If they are responsive, I want to know so that we can go look at them. But if they have a bunch of documents that aren't responsive to what we've asked for.
So let me, assuming that's really the case, I handle this, I've dealt with this issue quite a few times. So what I require, Mr. Zellers, you can make argument on this, but this is generally what I require. So if you're going to have hard copy documents or really voluminous documents, I'm going to require you to bait label each of the documents, and then say there's request for production number 1, Bates numbers 7 through 21 are responsive to that. You would need to say that in response to request for production number 1. Same with, and then request for production number 2, pages, Bate numbers 30 to 50. Then you would need to identify which documents are related by Bates label to each particular request. Does that address the issue? I'm not sure I'm following you, Ms. Bowen. Does that address your issue?
It does, Your Honor.
Okay. Mr. Zellers, do you have any opposition to that?
Yes, Your Honor. This certainly should be an issue that we can work our way through. There are a number of boxes of documents that were left by the plaintiff, Mr. Toubelet, when he left the employ of the defendants. Plaintiffs have issued over 200 requests, and it would be terribly burdensome to have to go through each document in these boxes of documents to try to piece them or attribute them to a specific request. The rules permit, and specifically Civil Procedure Rule 196.3A and C, that the documents can be made available for inspection in the usual course of business. We will be happy to work.
Mr. Zellers, are you saying that all of the documents that you're producing were originally Mr. Tubelow's documents that he left behind?
I am saying that all of those documents, at least to the best of my knowledge, are documents that existed as of the time that Mr. Tubelay left. To the extent that there are any documents that are in those.
That's not the same, Mr. Zellers. That's not the same thing. So are all of the documents So the way you described it, or at least the way I understood it when you first described it, was he had a bunch of documents. This is very old school, but he had a bunch of documents in a box. He left it behind at the company, and then he left, and now they're asking you to produce documents from those boxes. Is that what you're saying, or am I misunderstanding you?
No, you're hearing me exactly correct, Your Honor. The only exception that I make is that I can't represent. There's approximately 30 boxes of documents, and I would have to go back to our person in the office to confirm that all of these are documents that were left by Mr. Tubelay.
Ms. Bowline, is that accurate as far as you know, or do you know?
I don't know, Your Honor. That's the first time that I've heard exactly what these documents are in spite of my multiple requests. But having said that, if there's anything responsive in there, I'd love to have it. But for example, in the third set of requests for production, I guarantee you that none of Mr. Tubelay's documents are responsive with this third set of requests for production. And that's the issue I have. If these are just old documents that aren't relevant to any of my requests, I probably don't care about it. But I think that's the defendant's burden, is to tell me whether or not these documents are responsive.
Your Honor, we will work with Ms. Bowline to provide her an index of the documents, or an inventory, a general inventory of the documents, and we can work together to try to decide if she does need to inspect particular documents. But the plaintiff's requests are just incredibly broad. Produce anything that has been collected relating to the lawsuit, that relate to Mr. Tubelay, Sinostar, and so in terms of the request, they're very broad that have been made.
Sure. So, Your Honor, if I may, we're not here today about my request. The court's already overruled and ordered them to produce most of these documents. So, again, I've been talking to them about this for at least 2 months, Your Honor, saying, what do you have? What is it? Is it uniquely responsive? Has it been previously produced? Is it responsive to anything? And the defendants have refused to engage me on that. They've repeatedly said that they think their responses comply. And Your Honor, I don't think they do. So as you suggested earlier, I would appreciate it if you would ask them to Bates label it and tell me what documents are responsive.
I mean, and that's what I would normally do. I'm a little confused about these 30 boxes that Mr. Tubelay left behind. I mean, you're saying that's not what this is, right?
That's the whole issue, Your Honor, is I don't know what it is. They've never told me what it is. They just tell me it's their hard copy files. To the extent that Mr. Tubelay left them behind, I'm not really sure. I don't think that the defendants are saying that those are Mr. Tubelay's personal documents. That's my belief. Correct me if I'm wrong, Mr. Zellers, but these are the defendant's documents.
They are the defendant's documents, Your Honor.
They are, or they're not?
They are the defendant's documents that were left behind by many of which were left behind by Mr. Tubelay when he was the manager of defendants. Again, Your Honor, I believe we should be able to work this out. It would seem that we can work with Ms. Bowline to try to explain to her what's in. I do not believe there are any documents, Ms. Bowline, in that collection of hard copy documents that are responsive to your third set of requests for production.
And respectfully, Judge, as I said, we've been working on with this on him for 2 weeks. I've attached multiple emails. We've had phone calls. They just basically say, too bad, it's your problem. I'm not confident that an agreement's going to get it done. There are also a number of documents requests from the first set of requests for production that the court has already overruled their objections to. I don't know if they're responsive to that or not, because they won't tell me.
Your Honor, we are not Michael Zellers, we are not trying to hide any documents. We will certainly provide an inventory to Ms. Boline of what these documents are.
Mr.
And if
Zellers,
that's,
why hasn't that happened by this time?
Your Honor, we sent to the plaintiffs a discovery or a written protocol that would be followed for the inspection and copying of the documents. We were not successful in terms of trying to work out such an agreement. So defendants have tried to address this issue and work this issue out.
So let me make sure I kind of understand this. So there are some of the documents that are, and these are not responsive, I guess, to the third request for production, are Mr. Ziblay's personal documents, and they are hard copies. What documents are responsive to the third request for production?
Your Honor, I do not believe that there are any documents responsive to the third request for a production of documents in these hard copy files.
Okay, but what about electronic copies?
Well, electronic copies, and I'll address that separately. Whenever Ms. Boline is finished, those relate to the global AG issue, and I'll address that issue.
Go ahead.
But I'm not sure you want me to do that now.
Yeah,
So I guess that for the hard copy documents, my thought is that Mr. Zellers, I wish you knew whether or not these were all Tubelay's documents or not. And are they still in the same, like, are these just 30 boxes just stacked up that are his documents, and you guys have never gone through them, you've never reorganized them, you've never put them back with the corporate document or the rest of the company's documents? Is that your understanding? Yes,
we have not reorganized these documents. They're lease files, well reports, leases, and again, we can go through with Ms. Boline those documents and try to provide, or we will provide, an inventory of those documents. And if then plaintiffs wish to come and inspect and copy any of them, we'll make them available.
Sure. And Your Honor, if I may respond real quick before you make your ruling on this issue, it's the defendant's obligation to do a diligent search and tell us what they've got that's responsive. It's my understanding that with these 30 boxes of documents, which I'm just hearing about today, these are not, so that it's clear, these are not Mr. Tubelay's documents. These are the defendant's documents. And so what I would ask the court to do is to ask them to go through and tell us what's responsive to our requests. I think that's what the rules require.
Your Honor, last point, at a minimum, these documents are responsive to plaintiffs' request for production 165 and 167 in their first set of requests for production of documents.
They are responsive?
Yes, Your Honor. And those are very general requests that frankly virtually every document of the defendants is responsive to. But it's my understanding that these documents are responsive to those requests.
So I'm going to order what Ms. Boline just requested. What amount of time would it take you to do an inventory of these documents?
Your Honor, we're hampered somewhat by the fact that the person we would ask to inventory these documents is out on medical leave. I think we should be able to do it within 3 weeks, Your Honor.
Is that acceptable, Ms. Boline?
That's fine, Your Honor. Thank you.
All right.
Okay, so
first issue, so that needs to be done within 3 weeks. Now the next issue about these German documents.
Yeah, so moving forward, Your Honor, we had a hearing on this in front of Judge Craig back on January 5th on our first set of requests for production. She went through very nicely in great detail. We were there for a long time, and she overruled defendants' objections to 55 separate requests for production and ordered them to produce those documents. In that order, she ordered the defendants to amend their responses and produce all responsive documents on or before February, I want to say February 15th, Your Honor. I'm sorry, I don't have it up with me right now. the defendants never amended their responses. Instead, they served what they call supplemental responses in contradiction to the court's order. That was for both the request for productions and the interrogatories. In the request for production, they served an identical supplemental response to each one, Your Honor, and I'm going to read it into the record. The response to each of the 55 requests says, after a diligent search of documents in their possession, custody, and control, defendants have produced any documents that are known to be responsive that have been located. The issue that I've got with that, Your Honor, is that they've produced over 1 million pages of documents with no sort of classification whatsoever. And I can't tell from those responses if they're saying that they've produced documents or if they're saying that they will not produce documents.
Yeah, that's not acceptable, Mr. Zellers. You're going to have to provide, as I said before, an inventory. You're going to have to identify which documents are responsive to which request. And these are all going to need to be base labeled.
If I can interject briefly, Your Honor, we have produced documents, and we did base label all of the documents, and we produced them with metadata so that they're searchable by search term, they're searchable by to, from, CC, BCC field, they're searchable by date and by file path. And we produced them in that way. That was in line with the ESI protocol we had proposed earlier in this case. That's the recognized manner under the Sedona Conference for engaging in ESI to relieve burden on the parties and to make documents able to be easily searched. And that also does constitute production of documents as they're maintained in the usual course of business. Here we're dealing with over 100,000 documents that have been produced in the case and over 200 RFPs. If you do the math on that, it would be, well over 1 million, maybe tens of millions individual decisions that would need to be done for each of the 100,000 plus documents, go through each of the hundreds of RFPs and say, the document is responsive to this RFP, it is not responsive to this other RFP. There's just no feasible way that can be done. That's why we produce the documents with their metadata intact and in a searchable format. So that they fall under the category of documents being produced as maintained in the usual course of business. And I'd also point out that plaintiffs' productions were not made in the way that they're asking us to do it here. They did not go through and identify for each of the documents they produced which of the RFPs each document is responsive to, and that's just not practical or feasible for anyone to do. It would take tens of thousands of hours.
Ms. Bowen, is the electronic discovery searchable or not?
Oh, I believe it's searchable, Your Honor, but what Mr. Sindelar says fails to acknowledge that they haven't identified the custodian for a bunch of this stuff. So you know how I talked to you earlier about the AG's emails and stuff that are produced from super early on? Oddly, they left off the custodian, so you can't tell who it is. The bigger deal, Your Honor, this protocol that he's referencing, we don't have it in this case, right? And under the Texas rules, we're entitled to an answer. Are you producing documents or are you not producing responsive documents? That's what's before the court. That's what we're asking. I've gone through in my motion, it says ones that I haven't found. So for the ones that the court ordered the defendants to produce responsive documents for, Your Honor, I haven't found any documents that are responsive to request number 8, 15, 16, 20, 33, 38, 39, 40, 41, 42, 43, 70, 71, 72, 73, 76, on and on, Your Honor. And these are documents that should be in the possession of the AG, what we talked about earlier. It's my belief that what they're doing is trying to just say, go look at our 1 million documents without wanting to tell us whether they've produced responsive documents or not. I think under the rules, under 196.2B, I'm entitled to know for each whether or not they're producing responsive documents.
And if I may respond to that, Your Honor.
Yes.
So this is the first I'm hearing of the issue with the custodians, custodian not being maintained. That was our protocol to maintain custodians, and from the documents I've seen, we do have custodians listed. If there are specific documents where a custodian field is missing, we're happy to work with plaintiffs' counsel on that issue. In terms of if there are specific requests where they're
explain, I guess I'm not following what the issue is about the custodian. Like what, Ms. Bowen, what do you mean that the custodian is not identified? What is that? in this context, what does that mean?
So in these documents, the way that we've produced documents, Your Honor, is in a database, right? So it has all these various fields that you can take a look at. So in theory, I should be able to look and see if the defendant's documents came from, the defendant or one of the defendant's employees or the AG, right? What they've done is eliminated and unidentified the custodian for those. But that's not really why we're here, Judge. The bigger issue is that their responses don't comply, right? 196.2 requires them to respond for each, either we produced it or we didn't produce it. And so does the court's order, right? And they didn't do it, they failed to do it. And again, on those responses, they haven't said for anything that they're withholding documents for privilege. There's not a single response that says that they're withholding documents for privilege. However, they did finally provide a privilege log. It was late, but it's, I can't remember, 100 pages long, something like that, with all these documents that are being withheld as privilege, but they haven't in any response complied with Rule 193 to point out that they're withholding privileged documents. So I would just ask the court on this, Your Honor, real quickly, amend your responses and tell me if you're producing it or if you haven't produced it or if you don't have it, and amend it to say if you're withholding privileged documents that are subject to that request.
I think that's fair. I understand, and I don't know how to, Mr. Sindelar, is that how you say your name?
It's Sindelar. It's phonetically pronounced. Yeah.
Sindelar. Okay. I agree with Mr. Sindelar. Probably with this number of documents, it's not feasible to go through and identify which one is responsive to each one. You can do that through search terms. I do think that if you're withholding documents for privilege, you can't just produce a privilege log and then not say which documents in the privilege log are related to which request. I think you need to have some way for them to know what you're withholding and which, and I don't think that's unreasonable to do. I've never heard of a 100-page privilege log. Is it 100 pages that are withheld in a privilege log, or it's a 100-page long privilege log?
Your Honor, I apologize. I don't have it in front of me right now. Oh, here. I'm mistaken. I have it. It's 49 pages, Your Honor. 49 pages of tiny font, double-spaced or double-sided.
If I can speak to that.
Sure.
Yeah. So regarding the privilege, we provided a privilege log. It is timely. And the privilege log describes the documents that were withheld. It again has, who the document's from, who it's to, the date and the description. And we supplemented this morning in regard to this response and identified then that the documents withheld are responsive to RFPs 165 and 167. And we've given them information from which they can ascertain the privilege and the topic of the document.
Let me make sure I understand. So all of the privilege log entries, you've identified which request the documents are being withheld for.
We've identified for each of them that at a minimum they're responsive to RFPs 165 and 167. One of the problems again is that when you're dealing with over 200 RFPs, it's hard to match every document up to 200 some separate RFPs. And again, there's the issue of here, I believe Ms. Bowline has also stated, the parties have disagreements about what's responsive and what's not. So it's hard to say if a document is responsive to every specific RFP. Instead, what we've done is, we've searched documents trying to target all of their RFPs, including the very broad ones, and to provide those documents to them. And then in documents in which there was a attorney-client privilege or a work product assertion, we've provide information about the document sufficient to let the other side know what type of information is contained in the document as is required under the rules. And we're perfectly happy to work with the other side if they have questions about specific documents being withheld pursuant to privilege. We've identified those. And last I say is I think the privilege logs are on 49 pages and there are 557 entries maybe in there. But in a case like this where you are dealing with such a large volume of documents, you're talking about over 100,000 documents have been produced. well over 1 million pages. It's a very small percentage of the documents for which a privilege applies.
It's still 557 entries. I mean, that's not a small number.
If I can real quick, Judge, I think what Mr. Sindelar just told you is we think we're responsive, they're responsive to these two requests and we're withholding them, but we're not identifying each request. And again, on these responses, real easy. I understand that Your Honor's not going to make them Bates label everything and identify the specific Bates label. I'm fine with that. But what I want to know for each request is, have you produced the documents? Or are you saying you don't have any? And are you withholding anything that's responsive to privilege in connection with that particular request? Your Honor, it's 193.3. It provides that we get it for each individual request.
Yeah, at the very least, Mr. Sindelar, you need to produce for each particular request, are you withholding documents based on privilege? I know you'd like to be able to just do this catch-all and say it's just these two requests, but for each particular request, you're going to have to say which documents are you withholding documents for privilege and which entries are related to those particular requests. It's going to take a bit of time, but that's what you're going to need to do. All right, anything else, guys?
Yes, Your Honor.
If I can, I mean, I would just reiterate again, we have Bates labeled everything. That's not an issue. We've provided Bates labeling, and Your Honor, I mean, do we have to do a certain number of requests, or if a document is responsive to 50 requests, do we have to list all of those out? I'm just very concerned from a practical standpoint, given the scope of RFPs involved in this case, that it's going to be darn near impossible to inventory.
I mean, you've already gone through these documents and been able to identify that they're privileged, right?
We've done that, and it's cost over $150,000 our e-discovery efforts in this case. And I think, part of the reason plaintiffs haven't agreed to an ESI protocol and they keep raising discovery disputes is they're trying to just impose significant and wasteful costs.
Bowen, why haven't you agreed to an ESI protocol? I mean, I've signed the Sedona conference protocols. They seem pretty reasonable to me. Why haven't you guys agreed to an ESI protocol?
Sure. So, Your Honor, we went back and forth about this a bunch of times. The issues that I had dealt largely with the conference issues. Having said that, we have produced responsive documents in this requested format with the requested fields, right? I think that what Mr. Sindelar is trying to do here is say, I searched my documents and I gave you everything and that's all I have to do. And under the Texas rules, that's not it, Your Honor.
And if I can raise another point, Your Honor, I just pulled up plaintiff's privilege log. Their privilege log is 55 pages long. They didn't number the number of documents they're withholding as privilege, so maybe the pages to the number don't translate, but their privilege log looks like it's the same length of ours, and they don't identify.
I just want to say what's good for the goose is good for the gander. So if you are insisting on a particular protocol for their documents, your client's going to have to do the same thing.
I'm not, Your Honor. And as far as our privilege log goes, I've already told Mr. Sindelar that those documents aren't responsive to any specific request. What we did, because the defendants asked for it, we produced all of the global emails that my client had. So some of the issues in there were privileged attorney-client communications that aren't responsive to those specific requests. But Your Honor, if we can move on, I think the court's already ruled on this issue, and I've got a couple more important things, especially from this set, that I want to talk about real quick.
If I can just one more time, Your Honor, they also have not categorized what requests they're privileged to while they're wanting us to do that. And now they're saying they produced a privilege regarding documents that aren't responsive to any requests, and that they produced a bunch of documents that aren't responsive to any requests. And I think they are seeking a very asymmetric set of burdens here that are clearly designed to impose.
So let me just say this, and I'll say it one more time, Ms. Bowen, you come up with an order that reflects my ruling. Understand that what's good for the goose is good for the gander. If you're going to create a significant burden on them to respond, you're going to have the same burden. So really think through that, because I don't know that's what you want. I don't know if that's in anyone's best interest. So think about what you really need, put together an order, run it by opposing counsel. So we're running out of time, guys. So what else do you have?
Yeah, this is an important issue that I know Mr. Sindelar wants to talk about this stuff, but Your Honor, this is my motion that I really want to get through. They haven't given us verifications for any of the interrogatories that the court ordered them to answer.
You're gonna require to do verifications within 2 days, within 2 weeks.
Yes, they haven't given us compliant verifications for anything. You know, as the court knows.
I've already ordered, they have to do it within 2 weeks.
Okay, great. The next thing moving on is this motion on the third set, and I'm going to do it quickly, Your Honor. We found out in the course of the case, back in December, my client got a call from Dr. Mader, who was the former president of the defendants and the former CEO of the AG. He told my client about these communications that Mr. Crouchide, who is on this Zoom, you noticed earlier, Your Honor. I will note for the court that Mr. Crouchide is not an attorney. And also, to my knowledge, unless Mr. Zellers corrects me, I think it's the defendant's position that he's not an employee of the defendants. They had reached out, Mr. Crouchide, on behalf of defendants and the AG, had reached out to my client, or sorry, reached out to Dr. Mader to attempt to pay him in connection with controlling his testimony in this case. That email from Dr. Mader and the attached proposed settlement agreement is attached to our motion as Exhibit B, Judge. I think this is, you know, obviously it's very serious, a very serious allegation that we're making. We sent a set of requests on the basis of these documents, specifically tied to the things said in the documents, to communications with Mr. Crouchide and Dr. Mader, any of these things. I'll note for the court also that Judge Craig's January 12th order required these documents to be produced under request for production 73 and 76. They've made a number of invalid objections, one of those being to the time and place of production without any basis whatsoever set forth in the responses. And then when I contacted defendants counsel to ask him about it, they didn't give me any basis. They just said, maybe I'll produce responsive documents later. They've also got an invalid equally available objection, and they're saying basically you were able to get this document from Dr. Mader, who we're trying to pay. You know, you don't have to get it from us. And the problem I've got with that, Judge, is that they are the ones that have control of this. Mr. Crouchide, who's on this Zoom hearing right now, is the very person who is reaching out.
So are you saying that they're claiming that you have to get a document from a different defendant and it's equally available to that defendant, or is it equally available to your client?
Equally available to me, Judge.
But I mean, because you could also get it from Madar, or because you already have it?
They're saying that I already have it, right? And so the issue with this specific document, Judge, is that I got this, you know, Dr. Mader sent it to my client. I don't have this in a usable format, right? And this is a...
You need to tell them Mader's not.
Yeah, also, just so it's clear, Dr. Mader's not a party to this. We've asked for his deposition from the defendants. They won't make him available. Based on this settlement agreement, it sure looks to me like they're controlling his testimony. But the defendants aren't saying that. And Your Honor,
Have you compelled his deposition or not?
we haven't, Your Honor. We're still trying to get the defendant's deposition. I think we'll be back here on that next week. But the problem that we've got, Judge, is this global AG issue that they talked about earlier, right? Or that I brought up earlier. So I believe they're going to say that this communication was made on behalf of the AG. The problem is, had we not gotten this from Dr. Mader, we never would have known about these communications, which I still haven't seen, and this attempt to pay Dr. Mader not to testify in this case. I mean, Your Honor, this is stuff that's clearly relevant. And as I said before, you know, the AG is the agent of the defendants, right? It's their manager. Mr. Crouchide, the very one who is having these communications, is attending this Zoom on their behalf. And those agreements that we saw earlier gives the AG exclusive control.
And it goes to bias his testimony.
Yeah, it clearly would go to the bias of Dr. Mader's testimony, but also Mr. Crouchide's
So you're jumping
testimony.
around a lot here. What is it you want?
I want the court to overrule these inappropriate objections to time and place.
Hasn't Craig already ruled on these, Judge Craig?
Nope, this is a new set, Your Honor.
New set, okay.
But so so what I'm looking for is for the court to overrule their inappropriate objections to time and place and their equally available objections, and to order them to produce all the responsive documents, including those from the AG, which they're maintaining that they don't have possession of.
All right, response.
Your Honor, there are a number of issues. Let me start by saying that what Ms. Boline has said about Mr. Krauschied and his interactions with Dr. Mader is totally false and inaccurate, but that'll be addressed as we go through this case and when they take Mr. Krauschied's deposition in a few weeks. The Global AG documents, defendants, the U.S. subsidiaries, are not withholding any documents in this case. To the extent that there are any Global AG documents that are in the defendant's possession, those have been produced. Defendants continue to try to work with the parent and the parent's legal counsel to have additional documents turned over, made available to the defendants so that they can be produced. There's a number of German criminal, privacy, and corporate governance laws that we're needing to work through. But defendants are working to get the Global AG documents, and any Global AG documents that are responsive, that are come within the defendant's possession, custody, or control have been and will be produced. With respect to the verifications, a compliant verification was provided. Mr. Krauschied provided those verifications. Verifications are not required for objections. They are expressly permitted a verification to state that information is not within the affiant's personal knowledge and that have been obtained from third parties. And
so, Ms. Bowen, did they provide verifications you don't like what the verifications are, or
they did, Your Honor? They and I'm sorry if I didn't get to address that fully. So they did provide a verification. They provided a verification from Mr. Krauschied, who, it's my understanding, is not employed by the defendants. Mr. Zellers can correct me if I'm wrong, but that's my understanding. That's what they're maintaining in this case. As you know, Your Honor, the interrogatory verifications have to be provided by the party, right? Not an agent of the party. It's 197.2. It's clear. It's the law. They have not provided us with a verification from a party. And moreover, Mr. Krauschied and his verification.
Is Mr. Krauschied a party or not?
Mr. Krauschied is not a party. He's a representative of the party.
Does he work? I'm sorry. Does he work for your company?
He works, yes, but he is not an employee of the company, Your Honor. He works directly with a Global AG in terms of doing an investigation and audit of what occurred in this case.
All right, give me 1 second. I'll be right back.
Thanks, Judge.
All right. So on the verification, are you guys still there? On the verification, yes. So is there case law or rules that require someone who actually works for the company to sign the verification? Is that?
Yeah. So, Your Honor, 197.2D provides that a responding party, not an agent or attorney, is otherwise permitted, must sign the answers under oath. The defendants have admitted that Mr. Krauschied is not a party. And the other additional issue, Your Honor, is in those verifications. He just says, I'm confident or competent to make this verification. He doesn't provide any information about what the basis of his alleged competency is.
And Your Honor, under the rules and the case law, he's not required to do that. The cases that have been cited by the plaintiffs apply to a summary judgment standard, not to a verification of interrogatory responses.
Sure. And again, Your Honor, the defendants have admitted on the record that Mr. Crouchide is not a defendant or an employee of a defendant. They're required to have the party verify the interrogatory responses. They haven't done that.
Mr. Crouchide is a consultant for a global AG who is working with the defendants to do an audit and investigation in this matter, Your Honor.
And
Why
I think
why can't you just get an employee of the American company to sign it? I guess I'm not exactly clear.
Your Honor, if you order us to do that, we will try to do that. The person that we would go to is out on medical leave.
Okay. All right, same rule. You need to get a verification with someone in the company. All right.
Your Honor, just a couple more points. The objections that they're making as to equally available and time and place. Time and place objection is without any merit in terms of plaintiff's objection to the time and place. In terms of equally available, we've had extensive discussions and email communications with the plaintiffs to advise them that no documents are being withheld on the basis of being equally available. So we think we have addressed that issue and that it would just be an unnecessary burden to have to go through and restate all of the discovery of responses as the plaintiffs have requested, Your Honor.
Response.
Sure. So Your Honor, as far as this stuff goes, what we're looking for is to ask the court to order to produce the AG's documents. You just heard Mr. Zellers tell you that Mr. Crouchide, who they think is responsible for this case, it isn't employed by the AG. They haven't, or sorry, isn't employed by the defendants. They haven't produced any of that stuff. That's what we want. To the extent that they want to argue that the German entity somehow has some sort of international privacy regulations or whatever it is that they've gotten their responses, under 193.4A, Your Honor, they would have had to have produced evidence of that 7 days before this hearing. They didn't do that. Yeah, it would have had to be sworn, and they haven't done that. They haven't given us anything. And so, Your Honor, to the extent that they're not withholding anything on the basis of it being equally available, you know, I'm going to ask the court to amend and overrule their objections to the time and place, contrary to what Mr. Zeller says. They never gave us any basis for their objection to the time and place of production. They just said, we object. I wrote back and said, you know, hey, defendants, what's your basis? And they didn't say it. They just said, I think my responses are proper.
Your Honor, defendants specifically said that they needed additional time to do a search and try to locate any responsive documents. So that response was made and given in terms of adjusting the time and place for production of documents.
Yeah, I disagree, Judge. But again, these documents are all discoverable. It's stuff we need. To the extent that the defendants don't have them, that's a problem, right? They should have had them because it's between Mr. Crouchide and Dr. Mater. These documents are crucial to our case. Judge Craig previously ordered them to produce this stuff, and they didn't. And now they say it took us time to go back and look for it. Well, these communications were occurring, Judge, in September and in November, months ago, right? Months before their production was due. And so the idea that somehow they just get to say, oh, I get extra time. If they want extra time, Judge, the move is to either ask me for it or to ask you for it. The defendants don't get to do it on their own without stating a basis.
So any documents that have previously been requested by Judge Craig need to be produced within the next 2 weeks.
And does that include, Your Honor, the AG documents?
Anything that she ordered to be produced.
If I can make a few points, Your Honor, the time and place.
Guys, we're really running out of time here. So I understand that you guys want to kind of tag team this, but if it's been ordered by Judge Craig, you got to produce them within 2 weeks. That's the end of the argument. Guys, I need to go to my next hearing. Give me an order on this. And if there's more that needs to be brought up, you can reset this for the hearing. Ms. Boline, at the beginning of the order, make sure that it's says that this was heard on Zoom on April 8th, 2024. Give me as complete order as possible. Think about the language because it's going to go both ways if they request it. So be careful about that. run it by Mr. Zellers, and we will see you on the next one. You guys have a great rest of your day.
Let me
Thank
ask,
you, Your Honor.
All right,
Judge,
Mr. Steckler, I'm sorry, we've got another here. We've got to get to. I'm so sorry. Unless you guys are passing your hearing. Mr. Steckler, are you passing your hearing?
No, Your Honor.
No, Your Honor.
Okay, I got to get to the
I'll
next
try to
hearing,
be
guys. I'm
brief.
so sorry.
thanks,
Okay,
Judge.
thanks, guys. Okay, are both sides here on the Progressive Laboratories case?
Yes, Your Honor.
Yes, Your Honor.
All right, let's go on the record on DC 231839. Counsel, make your appearance.
Bruce Steckler and Austin Smith on behalf of defendant movement Damon Wolf.
Donald Kaiser on behalf of Progressive Laboratories, Inc., plaintiff.
So the first question I kind of have here, I guess, is should this case even be in my court, or should this be transferred to Judge Frazier?
I think it should be in your court, Your Honor, and let me explain why. It was first filed, I guess, in the court that Judge Frazier is now in. It
Okay.
was subsequently dismissed by agreement and refiled by Mr. Kaiser in this court. That case involves some other defendants as well as Mr. Wolf, and I can probably outline that legal landscape for you, but in essence, while they're
But
related.
the other side, I think, has said that a lot of these things have been ruled on before in the 44th. I don't know if that was by Judge Frazier or Judge Wysocki or Judge Colts. I know there's been some judges there in the 44th, but it doesn't really matter what the judge is. It really matters what the court is. I have emailed Judge Frazier about this. I don't believe I've heard back. Let me double check. And did Judge Frazier actually hear these previous motions, or was it a different judge?
No, Your Honor, it was an interesting situation. It was during that transition time with Judge Wysocki, and I believe it was Judge Mills ended up hearing it.
Jim Mills heard them by submission, so there was no actual hearing.
Okay.
Well,
Yeah.
there were a couple of hearings on a few of these different motions. I want to say that all three of those judges touched this case. I do remember Judge Mills sitting in for one of the hearings. And I don't think Judge Mills ruled on the MSJ, and we went right up to the cusp of trial. So I take that as a denial, but there was a written denial order at the beginning. And I believe that was Judge Wysocki, but I can check the order.
There was no oral argument that I'm aware of, and I'm not sure whether oral argument was even granted on this. Austin might be able to fill you in, Your Honor.
Respectfully, there were hearings on some motions to compel, some discovery related issues, but every motion for summary judgment was heard by submission.
Or not heard.
Or not heard, and they were ruled on by visiting Judge Jim Mills. And there's a signed order by him.
I mean, is there any disagreement? This seems to be pretty clearly to be a related case. Is there any objection to that, or?
Frankly, Your Honor, as a plaintiff, I hadn't thought of that possibility, but I certainly wouldn't have an objection. The court's record is pretty developed in that other court. I mean, this case started out as a case filed by Horn Brothers against my client, and we third-partied Damon Wolf into the case, and then settled with the Horn Brothers, and then by agreement, as Mr. Steckler mentioned, we non-suited the case and then refiled and of course got assigned to your court. But I don't know that I'd have an objection to sending it back there, because that's certainly where the developed record of these claims is, as we've stated in our response.
Hey, I have Judge Frazier on the phone. Hey, I'm so sorry to bother you. So I have I have Judge Frazier on the phone, and I've kind of explained the situation. I think it's a related case and should go back to her. She thinks if it's a related case, it should go back to her. Let me just put you on speaker if you don't mind, Judge Frazier. Is that okay? Okay. Judge Frazier is here. I want to make sure that, is there really a dispute that this is a related case under the local rules? I don't see how there can be a dispute because it was already brought up in the previous case, but is anyone disputing that this is a related case?
No.
Well, I don't think so, Your Honor. My concern is they dismissed the case. They refiled the case. We certainly didn't want to be named as a defendant. They didn't notify the court as required that it's related. I really don't know where they're headed with the case, but yes, it looks like the same prior case. The bottom line is my client is not a litigation pinata that they're just going to keep bringing into different cases. I need some finality here, and whether it is Your Honor who can address this summary judgment and let us have argument on it and get him out of a case for a judgment-proof employee of defendants, or whether it's Judge Frazier. This needs to be wrapped up. It involves a dispute from 2017. And I'm sorry that we refuse to pay any money on this, but we're not going to. So I'm not sure what's happening, but I need some finality, whether it's a trial or summary judgment, whether it's you or Judge Frazier. It's really of no import to us other than we're not in control. We can only try to get rid of it as many different ways as possible. So I'll defer to you all in your collective wisdom. I just feel like it's not incumbent upon us to notify these are related. I don't even know if it's related at this point. We've done nothing other than me saying, it's the same stuff. Get me out of here.
Were you able to hear that, Judge Frazier?
I did, yes.
I mean,
So me not having, I have no knowledge about what the facts are other than what Judge Hoffman has just said to me. So I don't know whether it's a related case or not. If it is related to the same facts, same issues, same parties, then I would say it's a related case and it should be back in my court.
Can I make a suggestion, Judge Frazier, if this is okay with you, is I think it's incumbent on you to make that decision if it's related. They did not designate this as a related case, which should have been flagged in so that you could see it. But the briefing all indicates, in my opinion, that it is a related case. It's not an identical case. It's because it was partly settled, but it sounds like the same issues. And so what I would suggest is have you send the case back to you. If you determine that you don't think it's related, then you can send it back to me. That would be my suggestion. But what do you think about that?
I'm fine with that. So what I'm also hearing is that the parties want a swift resolution. At least one of the parties want a swift resolution. And if it is a related case, you want it to be done as quickly as possible. Am I understanding that correctly?
Yes. Well, they're here on a summary judgment today, and so and one side says the summary judgment's already been ruled on in your court. I haven't heard the other side's view on that, so I don't know. Yeah, but yes, they want a swift resolution. Anyway, I'm sorry I interrupted you. Go ahead.
No, so I was going to say, summary judgment has already been briefed. It's already set for a hearing. I'm not sure what this does in terms of whether or not another hearing would be necessary or whether we could just, so that's, and you and I can visit about that, but I'm happy to look at it to see if it's related and try to get it moving as quickly as possible.
Okay. Well, why don't we, and if you look at it and you said it's not related, I'll just reset this because we're about to have this. We haven't had the summary judgment hearing yet. We're about to have it. And I looked at it and said, this is, to me, seems pretty clearly related case, but but they haven't briefed that issue. And so if one side is opposed to it, they can brief that to you. But if I was in your situation, I would definitely find it was a related case, but not every judge looked at it exactly the same. So, but go ahead, Judge Frazier.
I was going to ask, is there anyone that is disagreeing that it is a related case?
I don't think so.
Look, the bottom line is he didn't want to go to trial. He non-suits the case, refiles the case, doesn't mention it's related. And now no discovery's been done since it's been on file. Another continuation is granted. And now I'm being punted to another court out of their own malfeasance for not notifying that it's related.
Mr. Steckler, though, it's both sides' responsibility. It is primarily his side's responsibility, but both sides' responsibility to notify the court of its related case. I do think this is a related case. I mean, it's pretty clearly a related case. I understand your frustration. You want to get this resolved, but there's a procedure here, so we don't have, and this is really to protect both the whole system, is that we don't want forum shopping. If the opposing counsel, Mr. Steckler, was trying to avoid the 44th because they didn't like the previous judge or they don't like Judge Frazier, I'm not saying that's the case, and they non-suited to get out of it so they can get into another court. That's why we have the related case transfer, so you don't have forum shopping. And so, I mean, I think that, I apologize, this may take an extra few weeks. I don't know how quickly you could get a summary judgment heard, Judge Frazier, but I don't think it's unreasonable to follow the rules, which the rules are this seems to be absolutely clearly a related case. And Judge Frazier may decide, I'm not saying she will, may decide to sanction Mr. Kaiser. I've done that before. If she determines that he was trying to hide the fact that this was a related case. I'm not saying that's the case, but there is a remedy here if Mr. Kaiser was trying to forum shop. I'm not saying he was. That isn't before us today, but there's a purpose for these rules. I think the rules are good. These rules have been around since way before you and I started practicing, or all of us here started practicing. And I think they're good rules to make sure that we don't have forum shopping. And that's, so I apologize. There may be a short delay, but I don't think we should just throw out the rules because of that.
I appreciate that. Let me say this.
If I could respond, Your Honor. The court should know that this non-suit or dismissal or whatever we did was by agreement and after a discussion with Mr. Steckler, and they agreed to do this. There's no intent to forum shop. There were outlying reasons for why we did what we did. If we have to revisit those in the court, that's fine. But I want the court, both courts, to know.
Okay.
There certainly was no intent to forum shop and no intent not to designate this as a related case to.
So let's let Judge Frazier say, what was Judge Frazier, what would you like to do at this point? Would you like to reschedule the summary judgment? What do you want to do?
Yes, let's reset the summary judgment. I don't know when there is availability on the court. You will have to call back tomorrow and speak with Brand. Well, Brand is not there, but you'll have to speak with one of the, call back on the 11th, and Jonathan will be in, so you'll be able to reset it for a hearing on the 11th.
The call on the 11th, the hearing's not going to be on the 11th, right?
No, just call to schedule it on the 11th.
Okay.
Do the timelines still apply on this, or is it deemed filed in your court as if it had been filed in Judge Frazier's court?
In my opinion, this would be, you would not need to give 21 days notice, but Judge Frazier, what do you think?
So since it's all, I am tempted to say that no additional briefing on the matters that have already been set before Judge Hoffman should be allowed. And I would not require another 21-day notice. But to the extent that if you are inclined to brief whether or not it's a related case, or if you just want to move forward with a summary judgment, you're welcome to provide additional briefing with respect to whether or not it's a related case only.
Yeah, I think that's a great solution. All right, guys.
Let me just say something really quick, and I know you want to go, Judge. Mr. Kaiser, I don't think he intended to form shop here. I certainly don't want to make that accusation for both
Okay.
your honors. I think our thought was, let's just rock and roll and get this done. And I appreciate y'all both willing to just let us keep going. Whether it's a trial or summary judgment, I appreciate your time, and we'll get this thing moving. I'm sorry that it was such a cluster, for lack of a better word.
No worries. No worries. You guys are great lawyers. We appreciate everything you do. I just want to make sure we're following the rules. And if I was in Judge Frazier's situation and this happened, maybe Judge Frazier would feel the same way. I would feel like it would be my responsibility to hear this, since it was religiously in my court. So I wanted to make sure to give her the courtesy of making the same determination. So, so that's the only reason we're doing this. I'm not saying anyone's form shopping, but I do strongly believe that the related case rule is a good rule, that because sometimes people do try to form shop, and should not be allowed. So, all right, Judge Frazier, the email I sent you will detail what the case numbers are. If you have any other questions, just give me a call, okay?
Sounds good. Thank you so much.
Thank you,
Thank
Judge
y'all.
Frazier. Bye-bye.
Bye-bye.
Thank you, Your Honor.
All right, you guys just get that done, and you may want to get an order of transfer, if you guys can agree that, over to Judge Frazier. She's the one who's supposed to sign it. And if there's any issues, just let us know.
Terrific. Thank you so much.
Thank you, Judge.
You have a great rest of your day, guys.
All
You
right.
too.
Thank you.
Bye-bye.